Good afternoon, everybody. My name is Stanley Augustine, and I'm the Training and Outreach Program Specialist here at the DC Bar Pro Bono Center. And we want to thank you for joining us on our first ever interactive podcast for frequently asked questions around bankruptcy. This podcast will be with myself and Jeff Sherman, who does the trainings for our bankruptcy clinic. And all of the questions that we focus on today have been submitted by you and past attendees and volunteer attorneys with our bankruptcy clinic. Let me give a brief introduction of Jeff Sherman for those of you who don't know. Jeffrey M. Sherman is a creditors' rights and bankruptcy attorney with his principal offices in Arlington, Virginia and Washington, D.C. Jeff has represented creditors and debtors throughout the nation for more than 35 years. He works on behalf of creditors and debtors of all types, trustees, committees, and third parties affected by bankruptcy proceedings, including related bankruptcy and non-bankruptcy litigation. Jeff received his Bachelor's of Arts magna cum laude from the City University of New York, Queens College in 1978, and his Juris Doctor from the George Washington University Law School in 1981. Just a couple quick housekeeping items before I introduce Jeff. All of these questions that we'll be discussing and talking about today have been submitted by you, but if you have any questions in real time or any questions that you don't hear being addressed throughout the discussion that Jeff and I will be having, please, you'll see if you look down at the control panel that opened up when you logged into the training, you'll see a questions tab. If you drop that down, you'll see a text box where you can submit any questions. Just feel free to submit any questions you like during the podcast, and I will ask them to Jeff in real time. At this time, Jeff Sherman, please introduce yourself.
Afternoon, everybody. This is Jeff Sherman. Glad to have you on board. I understand that this podcast was sent out by invitation to people who had been through the bankruptcy training. So hopefully most of you remember me and remember the training and consider this a refresher and a supplement to what you've been told and perhaps experienced since the training took place.
Great, great. Well, I'm really excited about this because I'm not an attorney, but I've worked with you, Jeff, on several of our bankruptcy trainings, and I feel like I have a pretty good understanding of bankruptcy, so I feel like it puts me in a unique position to understand enough to ask you these questions in a thoughtful way, but I don't know enough where, hopefully I can help you, invoke really deep answers for our listeners today. So I guess let's get this started off. So our first question is, if the debtor has no employment income, but rather Social Security disability income, is it necessary to fill out a local Form 9? If so, why doesn't best case auto-populate the information into a form based on what has been provided in the form where other sources of income are allocated?
Okay. Local Form 9, if I recall correctly, Stanley, is the form that requires that you attach copies of pay stubs, or what they call pay advises, for the 60 days prior to the filing of the bankruptcy case. In a situation like that where the debtor has no employment, technically there are no payroll advises to attach, but the question assumes that the debtor is receiving Social Security income, which is payable, as I understand it, on a monthly basis. In that case, I would probably file local Form 9 and simply indicate that there are no payroll advises, but at the meeting of creditors, make the affirmative representation to the Chapter 7 trustee or the Chapter 13 trustee that the debtor is not receiving payroll-based income, but is receiving a fixed distribution amount on a monthly basis under a government benefit program, this particular one being Social Security, although it could be disability as well as ordinary Social Security. As for best case is typically very good at ensuring that forms are populated with information consistent across all of the forms that are necessary to be filed in connection with a Chapter 7 or 13 or even an 11. If you happen to experience best case for a Chapter 11 case. However, sometimes the local forms, while they can be populated automatically with things like the debtor's name, Social Security number, the chapter, the case number if it's already known, sometimes the requirement that the content of the local form stipulates is something that can't be populated by reference to another form. So no other form that exists that requires an affirmative representation that either there are or are not pay stubs that can be attached. So you manually would have to go into the local form to designate, in best case, that either there are none, or if there are some, that they're attached, and then manually go through the best case process to attach them.
Okay, and just, I'm thinking about this as you're saying this. There wouldn't be any hiccups or issues in not being able to explain that until you got to the creditors meeting. Just kind of putting that, that information will be provided later on.
Well, there's a couple of ways that it comes up depending on the chapter. Let's talk about 7s and 13s, because 11s are, for individuals, are pretty out there. In a Chapter 7, there really is no especially great concern about the debtor's source of income as long as they're under the means test, and Social Security doesn't count for the means test. So if you've got a debtor who's dependent entirely on Social Security and has no other source of income, the only place where their income would be consequential would be the means test or in the schedule of income. And in both of those places, you'd be able to designate that the debtor receives only Social Security, and that would be one way to disclose the fact that there are no pay stubs, which would be consistent with a representation in Form 9 that there are no pay stubs. In Chapter 13, because you have to demonstrate pretty much from the outset of the case that you have the ability to fund a Chapter 13 plan, it's more appropriate that you affirmatively represent that the debtor is receiving income, whether it's disability or payroll or retirement / pension or income from rentals or whatever it is, so that as early as possible in the case, the feasibility of the proposed repayment plan under Chapter 13 can be demonstrated objectively. So in a 13, I would be more conscientious about making an affirmative representation in Schedule I or in the Chapter 13 means test that the debtor does in fact receive income. In Schedule I, you can also indicate that there's a possibility for changes to the amount of income that the debtor receives in the box at the bottom of Schedule I for a narrative. So in a Chapter 7, it's not as consequential. You can get away with waiting until the 341 meeting to make a more affirmative representation that the debtor only receives Social Security, because it's not germane to the disposition of the Chapter 7. In the Chapter 13, because it's all income driven, you want to make a more affirmative disclosure and representation concerning the debtor's source of revenue and source of funding for the plan as early as possible in the case through Schedule I, through the Chapter 13, Statement of Income and Expenses, that sort of thing.
Very great, makes sense. Just to let folks know, so I see a couple more people joined us on the podcast. If you have any questions to ask in real time, not questions that you've already submitted, but if you have any follow-up questions or any new questions, please look on your control panel and you'll see a questions tab. If you click that, it'll drop down and you'll see a text box where you can send in questions in real time. So again, I see a few more people joined us. I just want to let you guys know about that. All right, so let's move on to our next question.
Okay.
Someone asked, please explain the advantages and disadvantages, the reasons for using or not using of selecting federal versus DC exemptions.
Okay, this is really a very, very critical thing. Here in DC, we're lucky because the state has not opted out of the exemption scheme that's otherwise available under the Bankruptcy Code. The Bankruptcy Code in Section 522 provides its own exemption protocol. Certain kinds of property are exempt and certain dollar amounts of property are exempt. And these are referred to as the federal exemptions or the bankruptcy exemptions. Each state as well has its own local exemption laws, which are not strictly limited to use in bankruptcy cases, but in fact are the general exemptions that are available to a judgment debtor or an account debtor when a creditor attempts to collect a debt as a matter of state law. So Virginia has its own state law exemptions. DC has its own state law exemptions. I use the word state advisedly. Maryland has its own state law exemptions. Now here's the thing. The Bankruptcy Code says each state can decide for itself whether to permit debtors who file bankruptcy cases in that state to choose either the federal exemptions that are in the Bankruptcy Code or the state exemptions, or to opt out, and that's the technical term, to opt out and only permit debtors to use the state exemptions and not be able to use the federal exemptions. Well, Virginia has opted out and Maryland has opted out, which means bankruptcy cases in those jurisdictions, the debtors can only use state exemptions. You can forget about the federal exemptions in the Bankruptcy Code. But in DC, we haven't opted out. So there's a choice between the DC exemptions or the federal exemptions. Now, a debtor can choose one or the other. They can't combine them. That's the first thing. The second thing is, if you have a joint case filed by spouses, both of them must pick the same exemptions. Both must choose the DC local exemptions, or both must choose the federal exemptions. Okay, why would you choose one versus another? The first level of analysis comes in the form of questioning the existence of equity in the residence owned by the debtors. First, if the debtors are not in ownership, but instead are renting, then this question doesn't even apply. So it only applies if someone owns their residence. If a debtor owns his or her residence, the next question is there any equity in the residence over and above all liens and mortgages against it? If there's no equity, then the issue of using the state versus the federal exemptions is pretty much ended. If there is equity, the next question is how much equity, reasonably calculated, is there? And the reason that this is important is under the federal exemptions, which you can choose in DC to utilize, there's a limited dollar amount of equity that will be exempt and can't be reached by the bankruptcy trustee and can't be reached by creditors through the bankruptcy proceeding. And that amount is roughly $23,000. So if there's less than $23,000 of equity in the real estate, the equity can be fully protected under the federal exemptions. If there's more than $23,000 of equity in the real estate, then under the federal exemptions, the amount over $23,000 can be seized by the trustee and turned into cash to pay the creditors. That's if you use the federal exemptions. If you use the DC exemptions, here's where the real kicker comes. DC is one of 4 jurisdictions in the country that has what's known as an unlimited homestead exemption.
Oh, wow.
That means...
So I don't know if you mind, but just to use my non-legal mind, does that mean that there's no cap on the amount of equity that can be protected through bankruptcy?
Exactly right. Under DC law, if your residence has been your residence for more than roughly 2 years, it does not matter how much equity you've got in that property. It could be $10,000, it could be $1 million. It is exempt from the reach of creditors, and if you choose to use the DC exemptions in bankruptcy, which you're permitted to do under the DC bankruptcy exemption options, then the entire equity would be exempt and beyond the reach of the trustee in bankruptcy based on the unlimited homestead exemption. So really, you would use the DC local exemption, the DC state law exemption, if you've got a lot of equity in real estate. That's the threshold. If there's no equity, if you have very little equity, only a couple $1,000s, if you are renting and not owning, if there isn't a lot of real estate equity, residential real estate equity, typically people choose the federal exemptions. And this is the second level of analysis for your exemptions. While the DC homestead exemption, the equity in your residence, is unlimited, The rest of the exemptions for personal property, cash, automobile equity, all those, that's fairly small. It's not very generous at all under DC law. So under DC law, you get a huge, unlimited real estate exemption, but only a cheap to moderate exemption for everything else, clothing, furniture, books, etc. The federal exemptions are much, much, much more generous when it comes to everything else. So if you've got somebody who's renting and has a lot of personal property, you know, they have, go federal. If you've got somebody who's got a lot of real estate equity, go DC.
Yeah. Yep. Okay. That makes a lot of sense. That was actually going to be my follow-up question once I understood that main advantage of using the DC code. I was going to ask if there were any other advantages to using either one, and you've kind of broken that down for us super simply. So yeah, everybody listening in, if your client has a lot of real estate equity, you want to go with DC, but if they have a lot of personal value in their stuff, then you want to go with the federal exemption.
Good rule of thumb.
All right, great. So let's move on to our next question. This is a little more specific. If a debtor has a car that they want to continue to keep, please provide the best approach to dealing with the financing company and the consequences of bankruptcy filing on this contract where payments are still due. So you know, if somebody has a car and they need their car to, you know, continue, you know, working or whatever like that, and they don't want it seized in bankruptcy, what's the best way to kind of negotiate or work with the financing company if they still need to make payments, if that's even possible?
Yeah, there are a number of ways to skin this cat, Stanley. First, let's talk about it again. In 7s and 13s, it's different, but let's talk about Chapter 7s first. In Chapter 7, because Chapter 7 is all about liquidation and it's not about extended payments or repayment plans or anything like that, basically in Chapter 7, if you want to keep a car that is subject to a lien, car financing, you have to maintain the payments on it. There's just no way around that. You're going to have to pay for the car in one form or another. You can't go through bankruptcy, keep the car, and not pay off the lien. So if you've got someone who is current on their car payments, they can go through a Chapter 7 and keep their car just by maintaining the payments. There's a little footnote to that, which hopefully I'll remember to get back to. However, if they are delinquent, if they're in default in their payments and they go through a Chapter 7, the Chapter 7 may wipe out the debt, but it doesn't wipe out the lien.
Okay.
So because of that, they either have to catch up what they fell behind or make some other arrangements, or else the lender still gets to enforce the lien against the car and can repossess the car once the bankruptcy is over and the automatic stay has been dissolved. So in a 7, if the payments are current, just keep paying for it. That's one option. If you're delinquent in Chapter 7, you're either going to have to catch up the payments or the car can be repossessed. Now, both of these assume there's no equity in the car. Okay. If there is equity in the car, then the Chapter 7 trustee, assuming it's not exempt equity, is going to want to sell the car to get the equity out of it, pay off the lien, and use the rest of the cash to pay the other creditors.
Yeah.
Now, there's a real interesting thing that's available only in Chapter 7 cases. It's a process called redemption, and it's provided for in Section 722 of the Bankruptcy Code. And here's how it works. Let's say you've got a car note, and the balance due on the car note is $10,000. Mm-hmm. And let's say that the car is now only worth $3,000. Under Section 722, in a Chapter 7 case, the debtor can basically buy back the car from the lender simply by paying off the value of the car in a lump sum, but only the value of the car, not the entire car debt. So in this case, the debtor could redeem the car just by paying $3,000 to the lender. Okay. The other $7,000 gets wiped out, gets discharged, as an unsecured debt. Well, here's the problem. Not every debtor can afford to write a check for $3,000 to redeem their car.
Definitely.
So what has happened is that somebody came up with the bright idea that they would create a company that would finance the redemption. In other words, they would make a new car loan, but just for the $3,000 necessary to buy the car back through the redemption process in Chapter 7.
Okay.
And this company is actually called, or can be reached through 722redemption.com. That's the name of the place, is 722redemption.com. And all they do is they lend the debtor enough money to redeem the car from the existing car lien and car loan, so that before bankruptcy, the debtor owes $10,000 on a $3,000 car. After the redemption, they owe $3,000 for the $3,000 car, and they've successfully redeemed it from the original lender. That's only available in Chapter 7.
Is there any impact on the bankruptcy because of this new financing if somebody was to, kind of try to exercise that option?
Yeah, the thing is that this new financing is enforceable as if there had never been a bankruptcy.
Okay. I see what you mean.
If a year later the debtor defaults on the redeemed or the redemption financing, they can be held personally liable for whatever the balance is, whether the lender gets it out of the car by repossessing the car and selling it or not. So it's not technically affecting the bankruptcy, because the bankruptcy will still wipe out the pre-bankruptcy debt. But this is a new post-bankruptcy debt that the debtor is incurring, so it's not going to be covered by the bankruptcy discharge.
Gotcha. Okay.
Now, that's what happens in a Chapter 7. In a Chapter 13, it's a little different. If the debtor wants to keep the car, what the debtor would do is, under the Chapter 13 plan, the debtor would repay the lender the value of the car over the life of the Chapter 13 plan. So unlike redemption under 722 that requires a debtor to pay a lump sum equal to the value of the car, in Chapter 13, the debtor could pay the value of the car over a 3 to 5 year period, and the balance would be considered an unsecured claim and would be treated just like a credit card or a doctor bill and paid pennies on a dollar. So that's the different way that a car is treated in a 7 and a 13. There's one more thing to consider. In Chapter 7, let's say that instead of being terribly underwater in the car, it's a much closer case. Let's say that you owe $7,500 and the car is worth $6,000. You could go through a process called reaffirmation, where you reaffirm the debt. And what that says is, attention world, even though I'm getting a discharge, I am still going to agree to be personally liable on this car note, in exchange for which the car lender is not going to take any action to repossess the car. See, what happens, Stanley, is that the filing of a bankruptcy is almost always an event of default under a car loan and under a mortgage.
Wow.
Once that's filed, unless the case is dismissed, the debtor is always in default because the debtor always has a bankruptcy case. If that was the situation, then in every bankruptcy case, the lender, by virtue of the bankruptcy default, would be able to come and pop the car. But we don't want that to happen. So what we say is, look, I know I'm in default by virtue of this bankruptcy filing, but I agree to basically waive my discharge and still be liable to you as long as you agree not to enforce that bankruptcy default and come and repossess the car.
Okay.
So that's the trade-off. I agree to be personally liable. You agree not to pop the car by virtue of the fact that I defaulted when I filed bankruptcy.
And this, hopefully, if you can answer this super quick, because we actually just got a live question I want to ask you quickly. But so, what does that look like? What needs to be signed, or what does that look like if somebody says, hey, even though I'm going through the bankruptcy process, if you promise not to repossess my car, I promise to keep paying you. What does that process look like?
Yeah, the bankruptcy law says that the debtor can reaffirm the debt by signing and filing a reaffirmation agreement. And the form that the court has on its website includes not only a reaffirmation agreement, but a motion addressed to the court to approve the reaffirmation agreement. And typically the court will grant approval of a reaffirmation agreement if it doesn't impose an undue hardship on the debtor to continue making payments on the car the debtor wants to keep.
Okay, sounds good. Okay, so we have a quick question. Somebody just sent this in. In a situation where a client is paying the attorney and filing fees for the bankruptcy with a credit card in advance of the attorney performing the work, are there any built-in hazards which the attorney should navigate?
The answer is yes. There's a couple of things that you need to be aware of, one of which is arguably a real problem. The other is more of a practical problem. First is, in 2005, a lot of changes were made to the bankruptcy laws that, in my view, were very anti-consumer and very pro-creditor. One of the changes that was made, among many changes, was the requirement or the limitation or prohibition on debtors' lawyers, which prohibits debtors' lawyers from telling their clients, their prospective bankruptcy debtors, to run up more debt. Okay. When a debtor uses a credit card to pay legal fees, you could see the argument being made that the bankruptcy lawyer has basically counseled their client to run up their credit card in advance of the bankruptcy to pay their fees. And arguably, again, a bankruptcy lawyer can't tell their client that it's okay or that they should run up their credit cards before they file bankruptcy. I haven't seen that. It may be out there. I haven't seen that litigated against either the lawyer or the client who becomes a bankruptcy debtor subsequent to running up the credit card to pay the lawyer. But it's something you always need to be aware of, because that's a pendulum that can swing back and forth very quickly. The second issue you have is that it is potentially a problem if the debtor uses a credit card and decides to dispute the charge on the credit card, even though they are receiving a discharge from the credit card debt. The debtor could, in theory, contest the charge and wind up with the lawyer who received the credit card payment having to give back the disputed credit card charge. Again, that would be a very unusual situation, but it is a possibility. As a general rule, I don't like to take credit card or credit card checks or cash advance checks just because of the questions about running up debt, that sort of thing. It is much safer, much easier to take a personal check or certified funds, or even we've had clients who have paid us in installments in cash, so that there's no question about the argument being raised that you've encouraged them to run up their debt before they file.
Yeah, no, definitely. That makes a lot of sense. I can see how that could become a sticky situation. We have one more live question, and this actually goes back to reaffirmation. Someone asked, can you reaffirm a secured credit line in Chapter 7?
You can reaffirm a secured debt. In fact, the court will almost never permit you to reaffirm an unsecured debt. You can reaffirm a line of credit, a HELOC, that is secured by a lien, deed of trust, a mortgage against real property. What we're seeing is that reaffirmation agreements are typically sought by car lenders as opposed to mortgage companies or equity line lenders like banks that have secured lines of credit. So it's certainly possible to reaffirm a line of credit or a HELOC or that sort of thing. But we're not seeing it being sought by the mortgage companies or bank lenders on those sorts of things very often.
Great, great. Thank you for that. All right, now we're heading back to our questions that people sent in. Our next question says, are federal and state income taxes owed dischargeable under Chapter 7? How do you calculate the amount that's dischargeable?
Okay, first, we're very lucky because as it turns out, the IRS has gotten much, much better at doing a correct calculation and determination on its own of whether and to what extent a debtor's tax liability is dischargeable or not. What will happen is that the IRS and, well, really just the IRS for now, the IRS will file a claim in a debtor's bankruptcy case in the form of a proof of claim. And in that proof of claim, the IRS will break down its claim into a priority amount and an unsecured amount. For your purposes, the amount that the IRS claims to be priority is the amount that is not dischargeable. The amount that the IRS says is a general unsecured claim is dischargeable. Now, DC doesn't do that, and the IRS doesn't always do that, although it's pretty good about it. So let's talk about the calculation and determination of what taxes are dischargeable or not. The general rule is that if a tax return has been filed on time, and that means not late, if it's been filed on time, including extensions, and if the tax return was filed but not paid, and if there is no assertion of any kind of tax fraud, not that there's an assessment of tax liability or a recalculation or that sort of thing, but affirmatively tax fraud. If there's no allegation of tax fraud, then you can get to the calendar computation of dischargeability. And here's how it works. If taxes came due more than 3 years before the bankruptcy case is filed, and a return was timely filed and there's no allegation of tax fraud, then the taxes are going to be dischargeable, both DC and federal. And that's a little hard to calculate in the abstract, so let's break it down in a real-world example. Right now it's November 1st, 2017. Mm-hmm. Let's go back to the year 2011. Okay. Taxes for the year 2011 came due on April 15th, 2012. If we were to file a bankruptcy case today, November 1st, 2017, that means that the taxes for 2011 came due more than 3 years before today.
Okay.
Now, for 2014, the taxes came due on April 15th, 2015. Mm-hmm. Well, that due date is less than 3 years before today. And those taxes are not dischargeable simply because of the fact that they are too young.
Gotcha. Okay.
You look at the due date for the taxes for the year that the tax return was due, and if that due date is more than 3 years before the date of filing, and there's been a timely return, and there's no hint of tax fraud, then the taxes should be dischargeable, both state and federal.
Okay, so I have a question then. That is assuming that the person is like current with their taxes. What is bankruptcy still viable if someone hasn't been current with their taxes, let's say 4 or 5 years, they haven't filed taxes in 4 or 5 years, would bankruptcy still be an option for them, or does that impact bankruptcy?
Yeah, not filing your tax returns is going to prevent you from getting a discharge in bankruptcy. One of the requirements of getting a discharge is that you must be current with your tax filings. Whether you're owed money in the form of a refund or you owe money in the form of a tax debt, you must catch up on your filings. You can do it during the bankruptcy. You're much better off doing it before the bankruptcy is filed. And there are actually a number of places where you can go and get some assistance in catching up on the filing of delinquent returns. There are clinics that can provide assistance to people in catching up with delinquent returns. I'm not sure if the DC Bar has a functionality to help people get their tax returns done, but there are places that it can be done.
Mm-hmm. Okay, thank you, thank you. So this is something that I've personally been thinking about. If you file for bankruptcy and you go through the bankruptcy process and everything happens well, how long would you need to wait in order to file for bankruptcy again? Do you need to wait in order to file for bankruptcy again?
Okay, the rule is you can't get a discharge in a Chapter 7 case more than once every 8 years, and that's measured from the date of the filing of the first case. So you can't get a discharge in back-to-back Chapter 7s unless they're filed more than 8 years apart. Chapter 13s, the rule is 4 years, because in Chapter 13 you're making some repayment to the creditors. So Congress said, if you've gone through the process of repaying your creditors, then we'll let you do it again more frequently if you need to.
Mm-hmm.
There's another aspect to this, which is sort of a corollary to the question, Stanley, that you just asked. When someone goes through bankruptcy, it stays on your credit report for 10 years by statute. And the credit reporting agencies, the CRAs, are actually pretty good at rolling off the 10-year or older bankruptcy filings from people's credit reports. So that's great. But here's the real-world consequence. When someone files a bankruptcy case, it is entirely possible for them to, for example, buy a car with a car loan and a car lien almost immediately after their bankruptcy case has been closed.
Wow.
I have a client for whom I literally just finished a Chapter 7 case. She just got her discharge on Monday. On Wednesday, she is buying a car. She went to the dealer yesterday, applied for the financing. She is going in today and picking up her car. So even though it's on her credit report, because of the nature of car salesmanship and car financing, the real world is a bankruptcy on her credit report doesn't stop her from buying a car with a car loan and a car lien immediately after she's gotten her discharge. And the terms that she got were only very, very slightly different than if she'd never had a bankruptcy. She had to put a little bit more money down. But that was it. That was the only side effect for her. What we're also seeing is that people can get back into the mortgage market 2 years after their bankruptcy case is closed.
Okay.
Banks are telling us, mortgage companies are telling us, they will consider applications for mortgages as long as the bankruptcy case is at least 2 years closed.
Okay. All right, that's good to know. What should you do if the debtor wants you to withhold certain information on the application that is required by law to be included? In terms of providing for this service that is needed to your client without violating the law as an attorney, how should you respond to a client who asserts that the information they want you to withhold from the application is the client doesn't have to be included because the information they shared with you during the interview is protected by the attorney-client privilege?
Yeah, fortunately, the answer to this is really pretty straightforward. If your client tells you that they have a debt or an asset that they do not want to list in their bankruptcy paperwork,
Okay.
you need to counsel them that they are signing their bankruptcy paperwork under penalty of perjury.
Wow.
And what they are representing when they sign is that their paperwork is true, correct, and complete. Now, here's an interesting thing, Stanley. There was a major change to the bankruptcy forms a year ago, December, and they changed the signature block for the debtor. It used to be that the debtor would sign all of the various paperwork, like the lists of assets and liabilities, things like that, under penalty of perjury, saying that it's true, correct, and complete to their best of their knowledge and belief. Well, that changed. It's no longer best knowledge and belief. Now the signature is an affirmative representation under penalty of perjury by the debtor that the bankruptcy paperwork being signed is true, correct, and complete, period.
Yeah.
There's no wiggle room saying to the best of your knowledge anymore.
Yeah.
If the debtor has told you that they have an asset or a liability or something else that they will not disclose on paperwork they are signing as true, correct, and complete under penalty of perjury, you must withdraw.
Okay.
You cannot be a party to perjury.
Yeah. No, it makes sense. What I guess just wondering, was there a lot of I don't know the best way to put this, but was that wording, that language changed because they saw a lot of people were trying to wiggle around exactly what information they needed to put forward?
Exactly. People would say, oh, I don't want to include, this car note, or I don't want to include this mortgage because I don't want to lose the property, or I don't want to reveal that I own a second car because I can't claim it as exempt and I'm going to lose it. And so the debtors sign the paperwork and they go, oh, well, to the best of my knowledge.
Yeah, I forgot. Oh, man, I forgot I owned these 3-4 other cars.
Right. So to get rid of that, they got rid of the gray area. They got rid of the wiggle room. And now it is an affirmative, positive obligation under penalty of perjury that the paperwork is true, correct, and complete, period.
All right.
So a lawyer simply can't suborn perjury by being the vehicle by which those perjurious papers get filed. You must withdraw.
Yeah, I don't think there's any more straightforward answer than that. If you don't agree with what the information they're trying to put forward, then you need to walk away.
Absolutely.
All right, so let's move on to our next question. This seems to be specific, so I'm assuming that one of our listeners sent this in specifically for something they're working on. A client has filed Chapter 7 due to a large amount of medical debts from a recent surgery and other debts. However, not all of the medical bills have been received. How can discharge be prolonged to make sure that all the medical debts will be discharged? Can this be a request to the trustee?
Okay, here's the answer. This is kind of an interesting little glitch in the bankruptcy law. What you've got is a situation where the debtor is filing a bankruptcy case but doesn't yet know for sure what pre-bankruptcy debts the debtor actually owes because all of the bills haven't come in, or they conflate the bill for the anesthesiologist with the hospital bill, but somehow their list of debts is not complete. And let's ignore the signature under penalty of perjury, that they're signing it because they honestly believe this is the entire universe of debts that they've got as of the date that they're filing. But it turns out that there actually were other debts that arose pre-bankruptcy that didn't get listed. Well, the date of the discharge doesn't matter, because what matters is the debts that existed as of the date of filing. So postponing the entry of the discharge doesn't change the date of the filing of the case, and the discharge, whenever it gets entered, will only discharge the debts that existed at the time of the filing of the bankruptcy. So merely postponing the entry of the discharge doesn't change anything, doesn't change the date of filing. But here's the thing. When you have a consumer bankruptcy and that consumer bankruptcy does not result in any assets being distributed to creditors. That's called a no-asset case.
Okay.
Where there is a no-asset case, creditors whose claims were unknown to the debtor when the debtor filed bankruptcy, those creditors never got notice of the bankruptcy because the debtor didn't know.
Yeah.
Well, in a case where there's no assets, then there's nothing that the creditor missed out on because they didn't get notice.
Yeah.
Even if they'd gotten notice, they'd still get zero.
Yeah.
So in that case, if it's a no-asset case for a consumer, for an individual, the debts will be discharged even if they didn't get notice of the bankruptcy.
Okay.
So let's say your debtor with medical issues, medical problems, has run up a bunch of medical bills and they only know about A, B, and C. So they list A, B, and C, they go through bankruptcy, it's a no-asset case. After the bankruptcy, they get a bill from the ambulance service, they get a bill from the MRI company, they get a bill from the X-ray technician for debts that arose before the bankruptcy was filed. That's critical. Before the bankruptcy was filed, these other debts arose, but the debtor honestly didn't know that these were additional medical bills. In that situation, all the debtor needs to do is to send a copy of the bankruptcy notice and a copy of the bankruptcy discharge to the creditors who are newly discovered, and that's enough to bind those creditors to the discharge.
Okay.
You don't have to go and amend. This is something that a lot of debtors' lawyers do. They think they have to amend the list of debts to include debts that they didn't know existed when they originally filed the case. If it's a no-asset case, there is no purpose served in amending the list of creditors because the creditors are discharged anyway because they didn't wind up being deprived of the ability to get something out of the bankruptcy.
Gotcha. And that's all creditors before the bankruptcy was filed.
It's only for creditors whose debts arose before the bankruptcy. It doesn't matter when the bill comes. It matters when the service was rendered.
Happened. Okay. And as long as that service happened before the filing, then, and it's an asset-free case, they don't have to worry about amending because of any new bills.
Exactly right.
Okay, great. All right. So somebody asked, when filing for bankruptcy, do all debts, current and delinquent, need to be listed? So they use the example of like a personal loan to a family member, things like that. Do those things also need to be listed?
Yeah, the rule is, again, since it's signed under penalty of perjury as being true, correct, and complete, every single debt that is owed by the debtor must be disclosed in Schedule D or Schedule E/F. No ifs, ands, or buts. Must be listed. Just because a debt is listed, however, and just because a debt might be discharged, doesn't mean that the debtor can't voluntarily repay any debt that's discharged. So if the debtor's got a personal loan and gets a discharge, the debtor can still voluntarily repay that personal loan. Here's another example. I had a client who was in the middle of orthodontia work that was going to take a couple of years.
Wow.
But she had to file bankruptcy, and she had an open account balance with her orthodontist.
Mm-hmm.
It was just a few $100s, but because it was a debt, she had to list it as a debt, and she listed it, and the debt was discharged. Mm-hmm. And the orthodontist said, look, I can't force you to pay back the amount that you discharged because you're protected from any effort on my part to collect it. But I'm not obligated to continue to render services to you. So you have a choice. You can go find somebody else, or you can continue with me, but I can't ask you for the money, but I'm not going to continue rendering services if I'm not paid. At that point, the debtor said, okay, I got a discharge from the $200-300. I want to keep using you, so I'm voluntarily going to repay the small dental bill with the orthodontist that had been discharged so that I can convince the orthodontist to keep rendering service to me. So you must list it. You can still voluntarily pay it, even if it's listed.
Gotcha. Somebody just asked to clarify what notice needs to be sent to late discovered creditors in a no asset case. I believe if I heard you correctly, no additional notice needs to be sent. It will be covered. But just in case I'm missing anything, can you please clarify if any notice needs to be sent to any creditor if any late bills were discovered in a no asset case?
Yeah, what I would do.
I'm sorry, and they said in addition to the order of discharge. So if anything else needs to be followed.
Yeah, what we send is two things. We send first a copy of the discharge that gets entered in the case, but also whenever a bankruptcy case is started, the clerk's office issues an official notice. And that official notice goes to all of the creditors and tells them the name of the debtor, the case number, the date of filing, the chapter, the debtor's lawyer, if any, the Chapter 7 trustee's name and address, or the Chapter 13 trustee's name and address. It tells the creditors about the automatic stay, and it lists a whole bunch of deadlines like filing claims or the deadline for objecting to a debtor's ability to get a discharge. That official notice, which is issued by the court, typically within a few days after the bankruptcy case is filed, we send a copy of that official notification along with the discharge. The discharge is generally just a one-page thing that just has a couple of lines on it that says that the debtor's received a discharge. All of the detailed information about the underlying bankruptcy case is in that official notice. So when we discover a pre-bankruptcy claim that didn't get listed for some reason on the bankruptcy paperwork, we will send both items to that creditor to make sure they know who the debtor is, when the case was filed, the chapter, and that there's been a discharge.
Great. Thank you, everybody, for listening as we go into the latter part of this interactive podcast. Jeff, somebody asked if you could discuss persona liability and in rem liability. They used the example of a client filed Chapter 7 and a mortgage debt was discharged. However, a client continues to pay monthly mortgage but is unable to receive a monthly statement. How can that client determine their mortgage balance?
Yeah, this is a really difficult situation that the mortgage companies have put their homeowners into. Here's the situation. A discharge in bankruptcy only wipes out the personal liability of the debtor. Remember, only an individual can get a discharge. Corporations, partnerships, associations, LLCs, nobody else can get a discharge in bankruptcy. Only individuals can get a discharge in bankruptcy. That discharge wipes out the ability of the creditor to come after the debtor individually. As a result of the discharge, there's no personal liability of the debtor for any debt that is covered by the discharge, which means any debt that arose prior to the filing of the bankruptcy. So from our law school days, this is what we refer to as in personam liability, where the person, him or herself, is liable for the debt. And that's in distinction to the ability of the creditor to enforce a lien or a mortgage or a security interest or a deed of trust against a particular piece of property or a particular asset. Like a car lender with a lien has a right to repossess and sell the car. The mortgage company with a mortgage or a deed of trust has a lien that it can enforce by foreclosure. Zales Jewelry has a lien on the jewelry that's purchased, and it can enforce that lien by having the sheriff seize and sell the jewelry. Those rights to proceed against the collateral that has been put up as security for the repayment of the debt. All of that is considered the in rem right of the secured creditor. The discharge that the individual debtor gets may wipe out their personal in personam liability, but it does not change the right of the secured creditor to proceed against its collateral. The bankruptcy colloquialism is that liens ride through. So unless something is done to void a lien, and there are a limited number of ways to do it, that lien and all of the lien rights continue to be fully enforceable, but only against the collateral. Now let's say it's a mortgage, and let's say that the mortgage is a $300,000 mortgage, but the property at foreclosure only fetches $250,000. That means the mortgage company has come up $50,000 short. Since the collateral is already gone, since the in rem right of the mortgage company has already been satisfied by selling off the property, selling off the collateral, the claim that the mortgage company still has, that deficiency claim of $50,000, can only be asserted as an in personam claim against the debtor. You can sue the debtor for it, you can get a judgment against the debtor for it, you can seize a bank account or garnish wages. There's no collateral left, so all you can do is go after the debtor personally. Well, the discharge in bankruptcy wipes out that personal liability. So in the event of a foreclosure, if there's still some amount of the debt left over after the foreclosure, if there's still a deficiency claim, that's an unsecured claim as to which there is only an in personam right of the creditor to proceed, and that in personam liability of the debtor has been wiped out by the discharge. So a debtor can't be chased for a deficiency for a car that's repossessed or a mortgage that's foreclosed upon by virtue of the discharge. The flip side is when the debtor gets a discharge from any liability, they no longer have a debt that they owe to the creditor. Their collateral is still pledged to the creditor, but the individual no longer owes a debt to the car lender or to the mortgage company. As a result of that, mortgage companies are saying, okay, if you got a discharge and you no longer have a debt that you owe to us, then number one, we don't have to report to the credit bureau that this account is being paid currently because it's not a debt that you're paying currently anymore because you don't have a debt.
Yeah.
And second, since you don't owe us any money, we don't have to give you any information about the debt that you owe because you don't owe a debt anymore.
Makes sense.
So mortgage companies are totally screwing homeowners who have been through bankruptcy by saying, number one, we're not going to report your continuing mortgage payments as current payments to help you rebuild your credit, and we're not going to give you any information because you don't have a debt with us anymore. You don't have an account with us anymore. We have no debtor-creditor relationship with you personally anymore.
Yeah.
So mortgage companies are just, they're really making it extremely difficult for homeowners who have gone through bankruptcy, who are keeping their property, whether it's a car, ignoring the reaffirmation, whether it's a car or a property, real property, because of this lack of an in personam liability on the part of the debtor. It's really making the rehabilitation and recovery of credit of people who've been through a bankruptcy proceeding substantially more difficult. And a lot of smart lawyers have been trying to find ways to get the mortgage companies to go back to reporting the account being paid currently and recognizing that the borrower has the right to know what the current payments are, what the tax escrow is, all that sort of stuff.
Yeah, definitely. Wow. Yeah. Well, the questions don't necessarily get any more easier. Somebody asked, so a student client was, they charged all of their education fees on a credit card. Since the student loan debt is commingled with the consumer debt, will all of the debt be discharged in Chapter 7? Will it matter that the creditor does not file a proof of claim?
Okay, the second part of that first. The non-dischargeability of student loans does not depend on either the filing of a proof of claim or a determination by the bankruptcy court. Student loans are automatically not discharged in bankruptcy, regardless of whether a proof of claim is filed. However, the flip side of that is also true. If the debtor wants to try to get a discharge from a student loan, the debtor must start a lawsuit to declare the student loan to be dischargeable. The burden is on the debtor to prove dischargeability because the debt is otherwise automatically not discharged in bankruptcy. Now, the interesting question is, what happens if a person takes a bunch of cash advances on their master charge and uses that money to pay their tuition and room and board and books and stuff like that? There's a generally accepted position that only student loans which are guaranteed by the federal government are not dischargeable. So unless the credit card company has you sign a separate rider that says this is a student loan, and that student loan is then guaranteed by the federal government or a state government, the fact that it's a cash advance for student loan purposes doesn't change the fact that it is just a cash advance, and therefore it is dischargeable.
But how, if that isn't disclosed, how would the creditors know that those cash advances were used for educational purposes? Wouldn't that, not to encourage anybody to, pay for their college or their children's college in cash advances, but if it just shows up on the statement as cash advances, wouldn't that be eligible for discharge if it isn't disclosed that that was used for higher education?
Yes, it would be up to the creditor to ask the question, what were these cash advances used for? But again, unless it's federally guaranteed, then it doesn't matter.
Yeah, you can kind of roll the dice on hopefully them being discharged.
Yep.
Okay. All right, makes a lot of sense. Okay, we're starting to wind down. I know we don't have much time left, so let's try and jump into these last few questions. Somebody asked, the client's employer filed for bankruptcy. The client is an independent contractor. The employer paid the client's salary outside the plan. The client received a letter from a trustee requesting payment from client for salary paid. Is the debt required to be paid? Can payment of debt be negotiated with trustee?
If I understand the question, you've got a debtor that's in, since there's a trustee, let's assume it's a Chapter 7. You got a Chapter 7 case for someone who had used your client as an independent contractor and paid that independent contractor.
Yes.
Okay, let's assume that that's the case. Now the trustee is saying, okay, independent contractor, you have to give that money back.
Yes.
There are only a couple of reasons why someone in that position would have to give the money back. Generally speaking, the trustee can recover pre-bankruptcy transfers that are made if they are either a fraudulent conveyance or what's known as a preference. A fraudulent conveyance in bankruptcy is just like a fraudulent conveyance under non-bankruptcy law. It has to be a transfer that's made for less than fair consideration that either renders the transferor debtor insolvent or is made while the transferor debtor is insolvent. There's a provision of the Bankruptcy Code that has its own fraudulent conveyance statute, which is Section 548, and the bankruptcy trustee in Chapter 7 can use Section 548 to recover fraudulent conveyances, but that only has a 1-year reach back. The trustee can also use the state law fraudulent conveyance laws, which is usually under the Uniform Fraudulent Transfers Act. I think it's either 3 or 4 year reach back. So that's one basis. If the trustee is claiming that the independent contractor received a fraudulent conveyance by being paid, then whatever defenses are available to the fraudulent conveyance are still available to the independent contractor. One defense would be, I gave good consideration for this receipt of payment. I worked, I rendered services, and this payment was in consideration of the services I rendered. Therefore, I did give valid legal consideration, and therefore it's not a fraudulent conveyance. There was value that was exchanged. The other option is that the trustee may claim that this was a preference. Now, a preference only exists under the Bankruptcy Code. There's no such thing as a preference outside of bankruptcy. What a preference is what it sounds like. Under Section 547 of the Bankruptcy Code, the Chapter 7 trustee can bring back payments that were made by a debtor during the period right before bankruptcy, where the debtor decided, I'm going to pay creditors X, Y, and Z, but I'm not going to pay creditors A, B, and C. And as a result of that, creditors X, Y, and Z got money right before bankruptcy, but the others didn't. So certain creditors wound up being preferred in the distribution of money right before bankruptcy. Well, one of the policies of bankruptcy is that creditors who have the same legal standing with respect to the debtor are to be treated the same. We don't want creditors rushing to the courthouse to get some kind of an advantage by attaching property or getting judgments or that sort of thing. So the policy of the Bankruptcy Code is all general unsecured creditors should be treated the same. And if right before bankruptcy the debtor has selected a couple or a few or some unsecured creditors and preferred them over other unsecured creditors, then the trustee is empowered under Section 547 to bring back the money that was paid to the preferred creditors so that it can be distributed equally among all creditors. That way, the equalization of the payment to the creditors results in the equal treatment of all creditors of the same type. Well, it's possible here that the trustee is claiming that the money paid to the independent contractor constitutes a preference. Normally, a trustee would assert in the alternative that a particular transfer is either a fraudulent conveyance or it's a preference. Generally speaking, the difference between the two is if the transfer was in payment of a debt, then it's arguably a preference. If the transfer was not in payment of a debt, then it's more likely to be attacked as a fraudulent conveyance.
Are there any if an independent contractor got called back to bring this money back for preferential equitable sharing of the money, would there be any consequence to the independent contractor if they tried to, file against this happening, or if they, for whatever reason said they didn't have the money anymore? Just very quickly, I know we're running out of time, but what would that look like on that side?
First, under Section 547, there is a whole long list of statutory defenses that the independent contractor can use. And they're like ordinary course of payment. If the independent contractor was being paid in the ordinary course of payment, that's a perfect defense by statute. Mm-hmm. In addition to those statutory defenses, absolutely the independent contractor can negotiate with the trustee to either pay back in installments or pay back in a lump sum, a reduced amount. When a trustee sues to recover a preference, the trustee does not have an entitlement to recover their legal fees. So if you say to the trustee, look, it's going to cost you $10,000 to litigate this preference against me, where you're trying to recover $15,000, how about I just give you $5,000 and you don't have to sue me, and we call it even. So absolutely, the target of the preference or the target of the fraudulent conveyance litigation can attempt to negotiate a settlement. No reason not to. Overwhelmingly, those kinds of cases do in fact settle.
All right. So this is the last question that I'm going to be able to ask because we're running out of time, but we did get through the vast majority of our questions. Again, I'd like to remind anybody who's listening in that we'll be joining the training tomorrow. We'll see you bright and early. I do see a couple of past volunteers and attendees online. If you have any questions, please reach out to Nakia Matthews or Jeff Sherman. So for our last question, somebody asked, and I don't know what this means, but they said, please discuss Section 722. Does this have any meaning to you?
Yes, 722 is the redemption section that we discussed before about what a debtor can do with respect to a car to buy it back from the lender for just the value of the car so that they avoid paying the entire debt and can wind up just paying off the value of the car.
Gotcha. Well, if we already covered that, let me get into one other quick question.
Yeah.
Can a person file for bankruptcy if they are not a citizen of the U.S. and what if this person does not have a green card and is in the U.S. on a lapsed visa? Please advise.
That's a really interesting question. The requirement to file a bankruptcy case is not limited to citizens. Anybody who is a resident here can also file a bankruptcy. An interesting question is, what is the extraterritorial effect of a bankruptcy? We've had a number of cases where, for example, someone who is a foreign national but working for the World Bank winds up having to file a bankruptcy, which they're permitted to do because they're a resident here, but they owe debts literally all over the world. And the question is, what good is a bankruptcy discharge from the United States if they owe debts in Korea or Europe or something? So that's an interesting question. But if someone is here illegally, if they're on a lapsed visa, they can't file a bankruptcy case. They have to be a legal resident. More importantly, if they're here illegally and they could file a bankruptcy, copies of the bankruptcy paperwork is sent to the United States Department of Justice. And I am sure, although I have no independent confirmation of this, I am sure that the Department of Justice has some kind of way to cross-reference the citizenship status of someone who is here legally or illegally. Plus, when you file a bankruptcy, you have to list a Social Security number. And it's pretty hard, but not impossible, to get a Social Security number if you're here illegally.
Yeah. All right. Well, thank you so much, Jeff. I know I learned a lot. I hope the attendees who tuned in got their questions answered. Again, we want to thank you all for joining us today. We do have part 1 of our 2-part bankruptcy training starting tomorrow, with part 2 happening on Monday. Again, if you have any questions, please reach out to Nakia Matthews at nmatthews@dcbar.org or Jeff Sherman. And again, we thank you for volunteering with the DC Bar Pro Bono Center. Have a great day.